Hey everybody, it's Adam Brown, A Brown ESQ, here with another appellate review. And today we're talking contempt. Now, you've been hearing the last few videos all about restraining order cases. There's all these restraining order cases that come down on appeal for family law. And by the way, we're still talking about unpublished opinions. They're unprecedented. They're not binding. You can't just cite them as law. We're talking about the unpublished opinions that come down every day almost. So anyway, we got a contempt case here. It's an FO case. And what's important to know is contempt is criminal. So when a contempt is criminal, it means that you face criminal prosecution. So this case is State of New Jersey versus, I'm not even going to say the guy's name. I'm going to use his initials, R.L., and it was decided January 2nd, 2024. You'll notice in these cases the initials, or at least in restraining order cases, their initials are used because it's confidential. So those are confidential identifiers. In these criminal cases, they straight up say like the actual person's name. I don't want to say anyone's name. I'm not interested in them themselves. I'm interested in the case. This is a case that comes out of Gloucester County. And it involves a situation that I kind of talked about before, and you see this stuff happen over and over, but it's about how this person violated a temporary restraining order. So there was a restraining order issued. He received a copy of it, and it says you can't have any contact with the person, any contact at all. And so in this case, somehow, some way, the wife who had the restraining order, she got a phone call from the person. Now, it's undisputed. Nothing was said on the call. There was no text or anything no voicemail left or anything like that. It was just a phone call. And so guess what? That is a violation. That's a violation of the restraining order. That's contempt of the restraining order. So this person, in his, defense, he presented an expert who is an expert on cell phones, and Lord knows how much that costs to pay somebody to go up there as an expert on cell phones. And the expert explained all the ways you can have an accidental call: pocket dialing, voice-activated Siri application, a spam call, spoofing, accidentally hitting someone's name after receiving a voicemail, accidentally designating someone as a medical contact, or a butt dial. There are all these speculative ways. It could have happened any kind of way. And the reason the defense, I think, did that was to show that, it wasn't intentional. Because remember, contempt is intentional. I knowingly violated this restraining order. It wasn't an accident. And I intentionally contacted the person. And so, the dagger for this person, in this case, for this judge, was that he actually took stand in his own defense. And when he went up there, he didn't say it was an accident. He just basically said, I don't know how it happened. I don't know. And the judge wasn't buying it. It wasn't a jury trial. You should know that about the contempt. It's a bench trial. The judge is going to rule beyond a reasonable doubt like a jury does. And the judge said, I can find beyond a reasonable doubt that because she got this call, that's you, on the call log, you did it. You contacted her beyond a reasonable doubt in violation of restraining order. Boom, it's over. And so he appealed saying, well, I had this sex, it could have happened any other way, I didn't mean to do it, blah, blah, blah. There are a lot of strategies people take in these situations. You can even, what I've seen on these appeals recently regarding these cases, you can file a motion with the assignment judge, like the boss of all the judges, and specifically say, this is a de minimis violation. Like, this shouldn't even be considered a violation. But this person didn't do that, and you would have to do that in advance. And even in those cases, the last appeal I read, and it's non-binding or whatever, but listen, the last one I read, even the assignment judge was like, on appeal, it's not de minimis. It's not so trivial that it's still not a contact. In that case, involved someone who was on LinkedIn, and they looked at the person's profile and it said, so-and-so viewed your profile. Even that was still a violation. So, and that's non-binding. I have to keep saying that because I don't want you to think like, maybe in other counties, maybe it could work. I don't know. I'm not telling you to rely on anything. But in that situation, it did. So anyway, shows you the severity. My advice, generally, you got a restraining order against you, lose that person's number in your phone. Absolutely lose the number. Just delete it immediately. Don't have any of your friends. I wouldn't even tell people about it unless it was my lawyer. Honestly, they might say, "Oh, so and so told me about," and it might be misinterpreted as you trying to explain the situation, third party contact. So it's so serious, these things, and everything's looked at. Don't send their mail back. Don't do anything that involves this person anymore. That's my advice. I wouldn't view their story. I wouldn't even go on social media because it's just so crazy how you can be violated. And when you're violated, you get thrown in jail without the cops just show up. You're violated. Boom. You're in jail instantly. That's what I got.